Okay, let's unpack this. Today, we're diving into a really fascinating legal challenge. It brings together, well, a former president, some core constitutional law, and that tricky intersection of business and public office. Our mission here is to explore the details of a court decision, a recent one where former President Donald Trump lost a bid to pause a pretty significant lawsuit down in Maryland. We'll break down what this actually means, for the legal process itself, but also for a wider discussion about presidential conduct, the main players,
Oh,
State
no.
of Maryland and the District of Columbia versus Donald Trump.
Yeah, and this isn't just like a dry procedural update. It's really a window into some quite complex constitutional questions.
Right.
Specifically, how a president's private business interests can, or maybe shouldn't, intersect with their public duties. I think the aha moment for you today will be understanding not just what these constitutional clauses are, but why they were put there in the first place, and why they still pack such a punch centuries later. It really gets to the heart of guarding against divided loyalties.
Okay, so at the heart of this, you mentioned these clauses. They're called the emoluments clauses, right? Now, that might sound a bit technical, maybe not something folks talk about every day, but they seem incredibly important for understanding the limits of presidential power and, crucially, preventing conflicts of interest. So how did these really old ideas, crafted for a totally different world, how do they actually apply today to a modern president with, global business interests?
That really is the crux of it, isn't it? The word emoluments itself, well, it feels a bit old-fashioned. It comes from a time when kings and officials might routinely take gifts, maybe lavish payments, from other countries, and that could, sway their loyalties away from their own nation. So the framers of the U.S. Constitution, they learned from that history. They put two distinct rules in there to try and stop that sort of thing for a president. First up, there's the Foreign Emoluments Clause. This basically says the president can't accept any kind of gift, payment, title, you name it, from a foreign government, not without Congress explicitly saying it's okay. The purpose is super clear. Stop foreign influence. Stop potential corruption. It's all about making sure the president's loyalty is just to the U.S., not to some foreign power dangling deals. Then you've got the Domestic Emoluments Clause. A bit different. This one stops the president from getting extra payments or benefits emoluments from the U.S. government itself or from individual states, beyond their official salary, that is. This is designed to prevent a president from, well, enriching themselves using the louvers of domestic government.
Public service shouldn't be a route to personal profit via the government machine, basically. And what's really fascinating, I think, is that the framers seem to understand that even the appearance of dodgy influence could be damaging. It could erode public trust just as much as actual provable corruption. So these clauses were designed to remove any potential financial temptation for a president apart from their salary, just to make sure their decisions are purely for the nation. That's the deep-seated intent being tested now in our very commercial world.
That really clarifies it. It shows how deep these ideas run, but also how modern their application can be. So, okay, we have that foundation now, what an emolument sort of means in this context. Let's pivot to the specific players. Who actually brought this lawsuit against the former president? And what exactly are they saying he did wrong? This isn't just some abstract argument, right? They're claiming real economic harm.
Precisely. Yeah, it's very concrete. The plaintiffs, the ones suing, are the State of Maryland and the District of Columbia. Their main claim is pretty direct. They allege that Donald Trump, while he was president, used his office to enrich himself. Specifically, through his continued ownership of the Trump International Hotel right there in Washington, D.C. They argue that various government entities think foreign embassies needing rooms, state officials visiting D.C., they deliberately chose to spend money at the Trump Hotel, booking rooms, holding events, that sort of thing. And the allegation is they did this not just because it was a nice hotel, but specifically to, well, curry favor with the president, to gain influence or maybe just get noticed. And this, the plaintiffs say, created an unfair playing field for all the other hotels and businesses in the D.C. area. They argue these other places lost out financially. Government officials, foreign diplomats, they chose the Trump property over competitors, motivated, allegedly, by wanting to get in good with the president. So yes, it's a claim of direct economic damage that stems from this alleged constitutional breach.
Wow, okay. So that unfair playing field argument, that sounds really central to their case then. It gives them the grounds to sue.
Absolutely central.
Yeah.
Because it gives Maryland and D.C. what's called standing.
Yeah.
It shows they have a direct stake, a direct injury. They're arguing harm to their local businesses, harm to their tax revenues potentially. Without that concrete economic injury, it would be much harder for them to bring the lawsuit. It moves it beyond just, we think the Constitution was violated to We were actually harmed because of it.
Got it. Makes sense. Now, naturally, Mr. Trump has his own side to the story. What's his defense against these claims? How does he respond to the idea that these payments were improper?
Right. So his team has consistently argued that he did nothing wrong, no crimes committed. Specifically on the payments his businesses received, like the hotel, the argument is that these were just normal business transactions.
Yeah.
People paid for hotel rooms, event spaces, memberships, whatever it was, at the going rate fair market value. So they argued these weren't gifts or prohibited emoluments in the constitutional sense. It was just business. He also, frequently characterized the lawsuit itself as political harassment, an attempt to distract or damage him.
That fair market value point seems key. Is that a standard legal distinction in these kinds of cases, or is this pushing into new territory for emoluments law?
That's a really sharp question because it hits the nail on the head legally. Trump's defense draws that line. Fair payment for a service isn't a prohibited emolument. He distinguishes between getting something for free or way below market rate versus a normal commercial exchange. And connected to this, his team also argued strongly, especially earlier on, about presidential immunity, that a president basically can't be sued civilly for actions taken while in office, particularly those connected to official duties. But here's the legal fiction and why this case is significant. The emoluments clauses, arguably, were intended by the framers to stop any financial link that could even appear to influence the president. So some legal scholars argue that even if a transaction is technically fair market value, if the reason the customer chose that business is because the owner is the president, then maybe it still creates the kind of potential conflict or appearance of influence the clauses were meant to block. The courts are really wrestling with where that line is in today's world. There isn't a long line of clear precedent on this exact issue involving a president's ongoing businesses. It's evolving.
That's a critical point. It really forces a reevaluation of what benefit or influence means when a president has active businesses. Okay, so let's zoom in on the specific court ruling that kicked off our discussion today. Mr. Trump wanted to hit pause on this whole lawsuit, right? While he appealed an earlier decision. What happened with that request? Did the court agree to pause things?
No, they didn't. The Fourth U.S. Circuit Court of Appeals, based in Richmond, Virginia, they rejected Trump's request for what's called a stay. A stay would have halted the lawsuit. So the court said no, the case keeps going. This denial came after that earlier key ruling back in March 2018. That was when a federal judge in Maryland first allowed the suit to proceed, importantly rejecting the argument that Trump was immune from this kind of suit while in office. So this latest Fourth Circuit decision basically reinforces that earlier green light. The case moves forward.
Right. So no pause. The lawsuit continues. What does that actually mean, practically speaking, for the case? And it's important, as you said, this wasn't the final verdict on whether he did violate the emoluments clauses, right? This was about procedure, whether the case stops or goes.
Exactly right. It's procedural, but with huge practical consequences. If we connect it to the bigger picture, the immediate impact is that the lawsuit keeps moving at the trial court level. The engine is still running, so to speak. This is a big deal for the plaintiffs, Maryland and D.C., because it opens the door wide for the next major phase, which is called discovery. And discovery can be, well, quite revealing. This is where both sides get to formally request and gather evidence. Think depositions, questioning people under oath. And really significantly here, potentially demanding access to financial records, internal communications, emails, documents related to the Trump International Hotel, its finances, and specifically its dealings with government clients, foreign and domestic. Discovery is often where the real facts of a case start to surface, so it's a critical phase. And beyond just discovery, this ruling sends a broader signal, doesn't it? It reinforces the idea that even a president or former president isn't completely shielded from civil lawsuits concerning their business conduct while in office.
It pushes the boundaries on accountability and could set a precedent for future presidents managing their own private interests. Now, Trump could still try to appeal the underlying decision, the one from 2018, that let the case proceed on its merits. But for now, the wheels of this lawsuit are definitely turning. It's moving closer to actually addressing those core constitutional claims.
And that matters for you, the listener, because this procedural step, denying the pause, it pushes the whole thing into the spotlight. It means the process moves into a phase where the actual evidence, the financial details, maybe the constitutional arguments, they get examined much more closely, potentially in public view. It's where the abstract arguments meet, well, the facts on the ground. So to recap, We've unpacked the emoluments clauses, that constitutional foundation. We've looked at the arguments from both sides in this pretty high-profile lawsuit, and we've analyzed why this recent court decision rejecting the pause is actually quite significant for the case moving forward. It's definitely complex.
It really is.
Yeah.
And it raises a fundamental question, I think, for all of us. This whole area where a president's private business life meets their public duties, it's just incredibly complex, and frankly, it's still evolving legally in the U.S. This case is a powerful reminder that our founding documents, like the Constitution, they aren't static. They get reinterpreted constantly by new situations, by new realities. It really challenges us to think hard about what public trust means, especially in a world that feels increasingly commercialized.
Definitely food for thought. And maybe something for you to consider as you go about your day. How might a president's business dealings, even if they are technically conducted at fair market value, as the defense argues, how might they still subtly influence, or maybe just as importantly, appear to influence government decisions, both here and abroad? And thinking about that, what level of scrutiny, what level of transparency do you think is really needed for those kinds of situations to maintain the integrity of the office? Especially thinking about preventing even the perception of undue influence. It's something worth pondering. Thank you for joining us on this deep dive.